So what really is the difference between a will-based plan and a trust-based plan? Hi, I'm Guy DiMartino. I'm an Indiana estate planning lawyer, and today I'd like to bring up this to you because I recently was involved in an in-depth discussion with somebody who was going through an estate plan. This person was dead set on a will. They did not want a trust. They thought it was too complicated, this, that, and the other thing. I said, that's great. You just have to understand how a will works and what is going on. So this is how a will works. A will only come into play if at the time of passing, the decedent owns whatever it is only in their name. So if they own a house and it's only owned in their name, that house is going to go under the terms of a will. And then it'll have to go to court and it'll have to be probated. On the other hand, if the person did a transfer on death deed, then at that point in time, at the time of death, an affidavit would need to be filed with the recorder's office, and the house could transfer outside of a will or outside of probate. So if you are really good, you can go ahead and put an estate plan together where you don't have to worry about anything as long as you have something set up where there are beneficiaries on everything. Beneficiaries on your bank accounts, beneficiaries on your real estate, which would be a transfer on death deed, beneficiaries on life insurance, beneficiaries on retirement accounts. As long as you're sure that all that's done, you're probably pretty much to go. However, if you have somebody that might have special needs in your family, or you might have somebody that has a spending problem, or you might have somebody that you're trying to protect from themselves if they get a lump sum of money, at that point in time, you may want to determine that you need a trust to manage those funds. If you have any questions regarding a will-based plan, you can always reach out to me. I am Guy DiMartino. Have yourself a great day.